I'm fine here, sir.
Will you kindly stand, Mr. Barnett?
Oh, is that an order, sir?
Yes.
In that case, you'll be requiring my bill then, won't you?
I'm not provided with.
If you're giving me an order, sir, you're liable for my bill.
I'm not. Mr. Barnett, you are subject to the law of this land, and you are before a court, which is a properly constituted court, which has priority over any other actions that you may have.
Sir, I am...
You are a defendant in an action for rape.
Sir, I am a man.
Do you occupy...
I am a man, sir.
Will you answer this question? Do you occupy a property in the parish of Montague?
I am a man, sir, and
Will you kindly answer that question?
I've got some questions to ask myself, sir, for clarification. I do not understand what's going on here today, and I require some clarification.
I am not going to pursue anything further other than to address the matter for which you came to this court. You have received a summons to appear before this court.
I've received what purports to be a summons.
If you are not prepared to address it, I will give judgment.
I'm certainly prepared to address it, sir.
So you will answer the question, are you an occupier of property in the national?
No, sir, I'm not.
Does your family?
No, sir.
Do you own property?
I do not. Sir, I'd like to ask some questions, please, if I may, just for clarification. I do not understand what's going on, sir, and I'd like to ask some questions. First of all, who is this person here, standing here? Who are you, sir?
This is, you kindly do not address anybody directly except through this seat.
Okay, sir, could you tell me who this man is?
The gentleman you are referring to is an activist in the world who is appearing on behalf of the parish of Martin. He is an official representative appointed to pursue the claims of the parish of Martin.
So, as an advocate, no doubt he's done his due diligence in this matter?
Yes, and he has...
And therefore... Sorry. Yes, sorry.
And he has told the court that he's been in correspondence, which I will now look at, with you, and that you have attempted to discharge your obligation by those rates, but have not completed it. I'm not going to...
So I'd like to...
Looking at which private and which has been handed up to me by Advocate Baxter on behalf of the parish of Martin is a summons that goes to you, and I'm looking at a letter in answer to the summons.
Would that be the notice and demand, sir?
The demand for rates, where you arrested the in a letter of 11th of November. And you state, I acknowledge receipt of your demand for rates. Unfortunately, due to my financial position, I am unable to deal with this in my normal manner. We will currently send the payment slip as an alternative method of discharge. However, you have not sent full instructions as to how this should be used. It is unlikely that you have come across the acceptance method of discharge before, but I can assure you it is in compliance with the Bill of Exchange Act 1882. Please send the acceptance together with a copy of this letter to the Treasury of the State. What you have said there is that you admit liability and you are attempting to make payment. The payment, it appears, am I right, Mr. Baxter, the payment has not been fully discharged. Now, that puts me in a situation, Mr. Private, where
Sir, could you not...
where I have in your hand, is that your letter?
Sir, I'm not Mr. I'm not a Mr. I'd just like to make that clear to the court. I'm a man. Do you understand that?
How do you wish to be addressed?
You can call me Cyril, please. Okay. Have you seen this? That was written in error as a mistake, and I have a notice and demand here that was sent to Collect Services, who apparently have made threats against me and demands against me.
Well, you think it wasn't a threat, it's a summons.
No, they've threatened to blacken my name, sir.
It's a summons to appear before a court of law, duly constituted court of law, to deal with a claim, and I have to adjudicate that claim. I see here your letter of the 11th of November, where you are admitting rate.
I'm admitting nothing, sir.
Yes.
In fact, that was done as a mistake, like I've already explained to you. And if you would read the notice of demand that I sent to...
I'm afraid the mistake is not available.
Well, I'm afraid it is. I'm afraid it is. Will you please read the notice that I sent to Collect, please? It's before the court, and I require you to read it.
Is that your signature?
I don't know, sir. As I said, anything that I've written to the Constable Yates, who actually isn't the constable anymore, was done as a mistake.
You wrote to his office.
As a mistake, sir. And I'd like you to read the notice of demand. It was my mistake because of misleading information given to me by the parish, sir. So if you would like to read the notice and demand, you'll see that I've asked for the parish and Collect to provide proof of their claim of this alleged debt. They have failed to do so, sir.
Mr. Baxter, proof of the assistant report. I'm not sure that one that we haven't is all I have available. Yeah. I imagine it just contains rate notice. Yeah. And our instructions for later name. What I have here is in this bundle. These are documents which you will have received, is evidence of the constitutional process of this island whereby local rates, parish rates, are collected of persons who occupy or own property in the parish, and they are duly assessed. When an assessment has been made according to law, that assessment is notified to the person who owns or occupies property in the parish, and that person subsequently, he has an opportunity to appeal it. If he is successful on his appeal, that rate assessment might be adjusted. If it is not adjusted and there is no successful appeal, the assessment is then made the subject of the demand for a rate. That is the contribution of the citizen who happens to occupy or own property in the parish towards the needs of the parish. And anybody living in the island, whatever he may call himself, whether he calls himself Cyril, Mr. Cyril Violet, or Jehovah, or whoever is occupying property or owning property in the parish, is liable on pursuant to that demand according to law.
So according sir, can I just interject a little?
Otherwise it will be in contempt. What I have here is your letter admitting liability. And there is evidence of correspondence, as you rightly note, between the former Constable Yates. And that letter is to the office of Connectal. He happened to occupy it at that time, which is as valid, because now that you have another constable, as he was then, it remains valid interest, which amounts to an admission.
I refute that.
I am accordingly going to give judgment against you.
I absolutely do not consent to this at all. There is no proof of claim of this alleged debt. If the court cannot see a proof of claim, you would please let me finish, sir. If there is no proof of claim of this alleged debt, then there is no proceedings. And if you do carry on as you are doing, I will be suing yourself and whoever else is party to this action in a civil court.
I'm giving judgment interest.
I do not consent to any judgment made by this administrative process. Thank you very much. Absolutely unbelievable fraud that's going on here. Unbelievable.